and supporting volunteer guardians. He currently serves as its Director of Education. They are partners in a law practice in Pennington, and I'm pleased to have Tony and Nina with us, and I'll turn it over to them.
Okay. Thank you, Dot. I appreciate that and the kind comments. And I welcome everybody who's listening to us. My name is Tony Serra, and I'm here with my partner, Nina Weiss. And we're going to spend the next 40 or 45 minutes or so talking about guardianship law, how to obtain it, and also some of the rules that come into play when you are a guardian. And this is a topic that we can spend several hours on, so we're going to try and get through this at least in a general way, so you have a pretty good understanding of what it takes to actually apply for and become someone's guardian. But before we get into the real particulars of how to do it, the nuts and bolts of it, we thought it was helpful to get an understanding of the philosophical basis for guardian, and also take a quick look at the history of it. So I think if you understand the philosophy behind it and why we have guardianship law, I think you'll have a better understanding of what the standards are when you become guardian and how to act as guardian. But philosophically, it's the case that all adults are presumed competent. It's really a constitutional requirement, and no one really argues that point, that all adults are presumed competent. And we reach adulthood, at the magic age of 18. Now, why is it 18? Well, it's somewhat arbitrary. I guess the law could have made that 17 or 19, but the law has identified 18 as being legally able to engage in an array of activities that someone at 17 couldn't do. And this is entering into contracts or giving informed medical consent, or just generally making decisions about where to live. So although as a parent you may not notice a difference in your son or daughter, when they wake up on their 18th birthday, in the eyes of the law, there's a significant change. Legal status has changed considerably. So that they're now adults, they're afforded the same rights and responsibilities as all adults. And this is why on a Wednesday you can access your son's or daughter's medical records, but on the very next day, on Thursday, the doctors won't listen to you because they're 18 and they have a right of privacy just like their parents do. Now, simply believing someone is incapacitated, even if that's supported by medical evidence, does not render the person incapacitated. Even if there's no question that a person lacks capacity, a lay or medical opinion alone does not render the person incapacitated. You need a court of law to render somebody, an adult, incapacitated. Now, historically, excuse me, our guardianship law derives from the English concept of parens patriae, and it's an Old English common law concept that the king would take care of his subjects who were unable to take care of themselves. Of course, back then it really meant the king took all the money from people. But in the last 40 or 50 years, when we adopted that doctrine, in the last 40 or 50 years, it's become more of a civil rights issue, and we've become more sensitive to this notion that people, have a right to independence and to choose. And so there have been laws now that have been passed that that now take us through a process of making sure that if we start taking these rights away from folks, that it's done correctly. So the law has grown up in the last 40 or 50 years, but it's rooted in this notion that we're trying to benefit people, we're trying to protect them against self-neglect and harm, and it's intended to shield a person from undue risk of harm, and it's not intended to punish anybody or to cause harm. But there is a very delicate balance between protecting people with diminished capacity and promoting and preserving their right to choose and their right to be make their own decisions for themselves.
Okay, so we're going to start getting into, that was a little bit of a background of the paradigm under which we're proceeding in the guardianship. But now we're going to get into a little bit of the nuts and bolts of exactly how you go about filing for guardianship in the courts in New Jersey. As Tony mentioned, just by saying or believing someone's incapacitated is not sufficient to have access and to make decisions. You must file an application in the Superior Court of New Jersey, and you file ordinarily where the person, the county where the person is residing. Guardianships are treated as an adversarial proceeding where the plaintiff, who's the person seeking guardianship, so if you're a parent over a child, you would be the plaintiff, you must prove the need for guardianship by clear and convincing evidence. It's interesting that it's treated as an adversarial proceeding. You know, as Tony mentioned as the background, we're trying to do what's best for someone, but at the same time it involves, you know, taking someone's decision-making authority away and vesting it with someone else. So technically it is an adversarial proceeding. The action's being filed technically against somebody. So the legal process requires the filing of several documents. First, the verified complaint, which is a document that essentially starts the action, and you're explaining to the court what you're looking for. You also need to file 2 medical certifications supporting the application and a certification of assets, and we'll get into this further along. The verified complaint must set forth certain basic information. It doesn't have to be overly detailed, overly long, but there has to be certain minimum information that you need to set forth to the court. The person's name, the address, and where they're currently residing, the plaintiff's relationship to the AIP. The AIP is the alleged incapacitated person. So either a mother or a father, or, you know, if it's Adult Protective Services, it could be a client. You also must set forth the name and best known address of the person's next of kin, which would be a spouse, children, siblings, and parents. And this is because these people will be entitled to notice of the application. So when you file the verified complaint, these people will be copied on the papers. You also must set forth the known assets, liabilities, and income of the person, and generally the factual basis for the guardianship, which basically means, you know, a brief history of their situation, whether it's a developmental disability or an elderly individual who's suffering from a dementia, and a little bit of factual background of what's been happening to the person and the need for guardianship. As we said, it must be supported by 2 medical certifications. This is essentially the evidence that's presented to the court to show the need for the guardianship. You need 2 independent doctors, and they must be able to provide a diagnosis of an existing medical condition that renders the person unable and unfit to manage his or her own affairs. Now, oftentimes, the medical certifications can be quite cookie cutter and generic, but oftentimes that might not be sufficient. It's very important for the attorney, when they're speaking with the physicians who are filing the certifications, that they explain the connection between the diagnosis and the need for guardianship. So for example, if it is a developmental disability, you need to say what that disability is and how that's impacting the person's life and why they can't make certain decisions. Another interesting requirement is that the complaint must be filed within 30 days of the physician's examination. So for example, if you have a child who's been seeing the same pediatrician for his entire life, and you last saw the doctor maybe 6 months ago for a general exam, you'll need to go back and have the doctor reevaluate your child for guardianship, because otherwise it would be considered stale. There are rules where the court can relax that requirement if it's a little bit out of date, but generally speaking, it has to be a recent exam within 30 days of filing the complaint. At least 1 certification must be from a medical doctor, and a recent rule change has said that the second may be from a psychologist who has a PhD. We'll speak about the importance of that later when we discuss limited guardianships, but oftentimes the psychologist can be very useful in giving the court a lot of background information about how the person is functioning day to day. The certification of assets is pretty straightforward. It essentially must set forth the person's assets, liabilities, and income as best as they are known to the person filing the application. And the reason why we say as best as they are known is because, by definition, the plaintiff is not yet the guardian, and they may not have access to all of the financial information. So essentially, it's a best guess of what the nature and extent of the assets and income are. What will happen, we'll talk about later again, is once you become guardian, you'll file supplemental documents with the court to show actually what the person has. But this, again, is just an estimate of what you know at the time when you're filing the application. It's necessary to make this disclosure so that when a guardian is appointed, we'll know whether or not to set a bond, and if so, the amount of that bond. And generally, the bond should be the amount of the assets in the estate so that it's all protected. The disclosure is also important for developing an appropriate care plan and the possible need for Medicaid planning or a special needs trust, depending if there are assets but that they do need some Medicaid benefits, there might be a need for the creation of a trust. That's for another day. That'll be for another webinar. As we said before, a guardianship is an adversarial proceeding. It's filing an action against somebody, and it involves taking decision-making authority away from someone, investing it with someone else, so it can represent a significant infringement on a person's right of self-determination and autonomy. And for that reason, there are several due process protections put into place. Right to notice, which means you can't file a guardianship without the alleged incapacitated person knowing, which sometimes is a factor. I mean, we'll meet clients from time to time who may not want to disrupt the apple cart as of yet and file an application, let's say, against their mother or their father and create what might be animosity in that relationship. So it can't be done without the person knowing. The person has a right to notice. Actually, get personal service of the court papers. The person has the right to an attorney, and we'll talk about that again a little later. There's a right to a hearing and an opportunity to testify in court. There's a right to cross-examine experts and witnesses. So, for example, if the person alleged to be incapacitated objects and doesn't want a guardian, their attorney might call in the physicians who certified as to the incapacity and cross-examine them on the stand. We've seen that, and it's very possible. Again, only in a contested matter would that happen. There's also a right to a jury trial, which we've never really seen, but there is that right that the person can ask for a trial by a jury. 99.999% of the time, there's a hearing before the judge, but the alleged incapacitated person can request a jury if they want. And there's a right to an appeal. Once the application is filed, the court will appoint an attorney to represent the person alleged to be incapacitated. And this is not, this is a mandatory requirement. It's not discretionary by the court. So if you file a guardianship, let's say for your child or for your parent, and you see that the court has appointed an attorney, that will not be unique to your case. In every single guardianship matter, an attorney is always appointed for the person. Actually, the person even has the right to retain their own attorney if they don't want court-appointed counsel. But generally, they accept court-appointed counsel, and that is in every single guardianship matter. And what's important for you to know as parents or as plaintiffs filing a guardianship is what the role of the attorney is so that you're not surprised about what happens during the course of the proceeding. The court-appointed attorney's role, very simply, is to be a zealous advocate for the stated wishes of his or her client, which basically means they're an attorney like any other attorney. If you go and retain an attorney, you expect that attorney to be loyal and faithful to your interests and to advocate for what you want. And a court-appointed attorney is no different. That is their role. So essentially, they maintain, to the extent possible, given the fact that by definition they are working with someone with a disability, they're to maintain a normal attorney-client relationship to the extent possible. They're also to interview interested parties and close family members and to advocate for less restrictive alternatives to a full or plenary guardianship, which could be a limited guardianship or a power of attorney or a living will. They're also to determine if a client has a will, a power of attorney, or a living will. And they also are to determine if additional medical evaluations may be necessary. For example, if the person feels that they don't need a plenary guardian and the attorney is advocating for a limited, they may need to get an additional medical evaluation supporting the need for a limited guardianship. After their investigation and meeting with the client, they issue a report to the court, and they recommend whether a case plan should thereafter be submitted. Some of you may have heard of the case, the matter of MR, in your travels in this field. Generally, without going into the facts of the case, it did involve a developmentally disabled young girl who had just turned 18, whose parents were divorced, and she was voicing a preference to live with the father rather than the mother. And the mother had filed for guardianship and essentially said, since she's globally incapacitated, she loses the right and the ability to make the decision about where to live. And what ultimately happened in the Supreme Court in New Jersey was that they said that it was the mother's burden to prove that her daughter lacked that capacity to make that decision. So in other words, this was the first time the court really recognized that we could have a limited guardianship. In this particular case, she was generally incapacitated and unable to make most decisions, though it was specifically stated that she may retain the ability to decide which of her divorced parents she wanted to live with. So it was a very seminal case in New Jersey, and the case is cited many times in reports of counsel in these matters. A court may also appoint a guardian ad litem, but it's important to know that the role of the guardian ad litem and the court-appointed attorney are very, very different. You may not always see a guardian ad litem, and generally speaking, in an uncontested guardianship, you probably won't see one because it's not mandatory, it's discretionary by the court. But the court may appoint a guardian ad litem if it determines that the person is espousing a position that is, quote, patently absurd, or where there are, quote, special circumstances. And you may say, what does that really mean? What is patently absurd and what are special circumstances? And essentially that's dealt with on a case-by-case basis. You know, it's really hard to say, you know, I guess if a person says I want to go live on the moon, that might be patently absurd. But if they want to continue living in their house where there's a lot of hoarding, that may not be. There's a fine line between, you know, what's acceptable and what's not. So essentially the role of the guardian ad litem is to give a best interest evaluation regardless of what the person is asking for. So this is a more objective approach. Whereas the role of the court-appointed attorney is to advocate for what the person wants regardless of what the attorney believes is in the client's best interest. So this is a more subjective approach.
Okay, now, in order to file for guardianship against somebody, you have to have some relationship to that person. Like we just talked about that earlier, about you know, who can file. But in legal terms, you have to have standing, and that's really means the right to file. And you know, a mere stranger cannot file, and that's for obvious reasons. You just don't want, you know, people who may have other, you know, another interest, their own interest to file, being able to do that. You really have to have some interest in that person. Usually it's a family member, but as we pointed out before, it can be, if it's somebody in the community, if it's an adult protective service situation where there's some abuse or neglect, that agency will come in and try and resolve the situation and try to offer services. But if they feel the person, is not accepting the services or is not able to really comprehend what's being offered, in many cases they will file for guardianship in order to have a plan put into place. We've seen financial institutions who might be trustee for somebody, where that person now is no longer able to manage effectively. They can file, and in many cases, hospitals and nursing homes file. If there's a medical decision that has to be made, and the physicians feel that the person cannot give informed consent, they will file. There's something called a special medical in case of a procedure that has to be taken care of right away. There's procedures for that. Nursing homes file a lot in order to collect their fees and their costs because the person is not paying the bill, and you can't find the family, and the family's not paying the bill. So that could also trigger a guardianship. And we've also seen private care managers actually be in a position to file. The legal standard for declaring somebody incapacitated, and we quoted it here on this slide, is a very broad standard. And it's essentially a finding that a person is unfit and unable to govern himself or herself and to manage his or her own affairs. It's not very specific, but that's the standard, and it allows the court to have some freedom to judge different situations. If the court makes that finding, they may appoint a general guardian who will exercise all rights and powers over that person. And as Nina mentioned before, the case must be proven by clear and convincing evidence, which is a relatively high burden of proof. We hear in these criminal cases the standard is beyond a reasonable doubt, and this standard is slightly less than that. It's not quite the standard you would have in a criminal case, but it's certainly more than a civil case. The standard for a civil case would be, by a preponderance of the evidence, which is 51% or more. Here it's in between those two standards, so it's a relatively high standard. So essentially in a guardianship, the court is going to make two determinations. They're going to first make the determination of whether the person needs a guardian, and maybe the proofs are not sufficient enough, or maybe a court-appointed attorney gets another doctor to contest those reports. So you could have a case where a person is not found to be incapacitated, and that could be a reason the case could be dismissed. Another reason could be that there might be an alternative to guardianship. The person may have capacity to enter into something voluntarily, like a power of attorney or a living will, or a conservatorship, and that's a court proceeding, but it does contemplate someone who has a need but is competent to have somebody appointed to be their surrogate. So that could be another reason why the case doesn't go forward. But once the court makes a finding the person is incapacitated and needs a guardian, then the second question is, who that guardian should be. And in most cases, if it's contested, that's the issue, because people are going to be fighting over, over the control of that person's life. So, if the court determines that a person is unfit to manage his or her own affairs, a guardian will need to be appointed both over their person issues, their medical, meaning their medical and social and residential issues, and also over their property issues, over the management of their assets, of their income. So typically the same person is appointed to fulfill both of those roles, to be guardian of the person and of the property. But in some cases, the role can be split, and it can be done in different ways. You can have one person guardian of the property, another person guardian of the person, one of the property, one of the person, depending on their interests and their expertise. Or you can have co-guardians, where you have two people sharing that responsibility over both person and property. And I just had a case we resolved. We have 3 people actually, three kids. And so you can be somewhat creative, but the problem is the more you have, the more potential for conflict. So the courts are generally not that happy appointing more than one person. If the court makes a determination the person needs a guardian, they will enter what's called a final judgment of incapacity, and that's the formal document that you get with the judge's signature on it, and it'll it could be 4 or 5 or 6 pages long, and it's got the language in there as to some of the duties and responsibilities of the guardian, responsibility to file accountings and inventory, to have access to medical records. So depending on who's drawing up the judgment, some are a little more comprehensive than others, but it'll certainly declare the person incapacitated, and it'll also appoint those fiduciaries, the guardians. When you are appointed the guardian and your name is in that final judgment, you're not really the guardian yet. You have to go to the surrogate's office in the county where that case was being heard, and that's a county office. The surrogate is a county office, and you have to qualify. And what that means is essentially sign papers that you are accepting that appointment. It's very close to the situation where someone appoints you as executor of their will. Just because someone appoints you executor of their will doesn't mean you are the executor or executrix. It just means they want you to do that. You could not accept that, and the state will have to find somebody else. But if you accept the role of executor, you have to go and qualify. That means accept the position. So the same thing here. The judgment will appoint you, but if for whatever reason you don't want to do it, you don't have to qualify. In some cases, there is a bond required, and as Nina mentioned before, that's a requirement in some cases. And just so you know, a bond is not a liability policy. It doesn't protect the guardian from liability. It actually is almost the opposite. It really protects the ward from potential bad acts by the guardian. So that's what a bond does. But don't be offended if a court wants to bond you. I get appointed in case, we get appointed in cases as attorneys, and we have to be bonded as well. So most judges today are really bonding everyone, maybe a very close family member, maybe not, but the policy now is essentially to have everybody bonded. Unfortunately, it costs money, but that's just the price of this sometimes. Once you get your bond and you accept your role, then the surrogate will issue letters of guardianship, and that will be the official document that you'll use to go to the banks and make transactions and conduct business. The scope of guardianship. Okay, guardianship could be either full or plenary, or they can be limited. Again, the legal term of plenary means full, and that's really ought to be reserved for individuals who lack really all capacity to make decisions for themselves. The obvious cases of someone who's in a coma or severely handicapped in some way, who really lacks all the ability to express preferences. This clearly would fall within that category. But in some cases where there's some retention of capacity, the right tool then is the limited guardian. And as Nina mentioned before, the 1994 case of MR was really one of the first times that our court recognized that the law views these things on a sliding scale, that there are degrees of diminished capacity, and the law really hadn't caught up with the medicine at that point. But from 94 on, there's been talk about it, and the statute was changed a few years ago to specifically now talk about that this can be a possible outcome. And in many cases, in many areas, we talk about least restrictive approach. We do that in the education field. Well, that's certainly true here. You don't want to have more restrictions than are what are necessary. So you want to go with the least restrictive approach. If there is a basis for a limited guardian, that should be considered. And also, as we mentioned before, now that you can have a psychologist as one of the certifying doctors, it would be helpful to have a psychologist do a functional assessment if you did feel that the person retained some capacity, because that psychologist may be able to articulate a little better, what capacity that person can retain, because that has to be in the judgment. You have to articulate that and reflect that in that judgment of that final judgment that we talked about. Accountability. Okay, so this is a big issue. As we mentioned before, when you file your complaint, your certification of assets may not be comprehensive because you're not guardian yet. You may not have access to a person's finances. But once you become guardian, you need to reach out and and discover what the assets are, and look through the mail. If it's a situation where things are scattered, check the mail for statements, go through unopened mail or go through files, and really try to identify and marshal those assets. And then you'll be required to file an inventory, which is sort of a snapshot of what those assets are within 90 days of your appointment. The court figures that within 90 days, you should have a pretty good handle on what the assets are. You will then have to file annually what's called an informal final accounting, and that's, in the relatively simple cases, it's really nothing more than a check register showing your starting balances, which really should tie into your 90-day inventory. So if your 90-day inventory is saying there's $125,000 in assets, then your accounting should really start with that balance. Obviously, take into account any income for the year and then any expenses, and then your ending balance should reconcile. You're also required to file, along with your financial accounting, a report of well-being, so the court can get a sense of how they're doing medically and in terms of their living environment. You need to keep a good sense of what's happening in that regard, so you can report to the court. The personal property should be inventoried and safeguarded. If there are expensive rings laying around the house and caregivers coming and going, they probably should be secured somewhere where they're safe. And any other, if there are collections that are of value, you really need to make sure that that they're not exposed to outsiders. And then each county, although it varies from county to county, some are a little better than others, but most of the counties have some process of checking in on you and doing monitoring of you, other than your accountings. And in fact, in Hunterdon County, they've got a program where volunteers will actually go out and visit the ward and follow up on the accountings and talk to the guardians. So if that's in place in your county, you obviously want to cooperate with that process.
So now that you're the guardian and we've gone through what your requirements are, generally your day-to-day work will be around making decisions for the person. That's really the crux of what being a guardian is. So we wanted to talk to you a little bit about how a guardian makes decisions.